Good morning, everyone. My name is Eric Walliver, and I'm the Executive Director of USES. If you're joining us again for this webinar series, we're glad to have you back. If this is the first time you're joining us, welcome. USES, for those of you that are new, stands for the United Solar Energy Supporters. We're a grassroots community of activists who support solar power, and we're very much into educating all audiences on solar and the many ways when it can be beneficial to landowners, communities, and of course, most importantly, to our environment. At USES, we've been hosting these webinars for more than a year, and we're looking to get your feedback. At the end of this webinar, you will be receiving a survey, and we hope you'll take a few moments out of your time to let us know what topics you'd like us to be covering in the future. As I said, we've been doing this for about a year and we've had a good response. We've covered a lot of different topics, but we're always looking to hear what's on your minds and what we can do to provide you with additional information. Today's webinar is on solar law. We'll be reviewing various community and environmental factors to consider when developing local solar law. We will provide a high-level review of all aspects surrounding various types of solar projects, with the greatest focus on commercial scale projects that can be regulated at the local level by municipal zoning and land use laws and regulations. Again, we want to remind everybody that we do give training certificates to municipal employees. If you're looking for one of those, please email us at eva@usesusa.org. USSUSA.org. From here, we're going to listen to hear from our presenters, and then after that, we're going to have a question and answer section. We'll wrap up at 11:30. If you have any questions, please feel free to put them in the chat, and we'll get to as many as possible. Without further ado, let me introduce you to our first presenter, Barbara Johnston. She is a senior planner with Labella Associates in Rochester. Barbara has more than 25 years experience in local government planning and land use regulations. She has assisted numerous municipalities across the state in planning for renewable energy efficiency, and energy infrastructure while maintaining local conservation resources and development priorities. So with that, I'm going to pass it over first to Barbara.
All right, it's a pleasure to be here. Thank you for setting up this webinar. Solar energy is coming across the state to your community and to your neighboring communities. And I understand that many local governments are concerned about how to prepare. So hopefully this session will give you some orientation as to what solar developers are looking for, what resources are important to consider when you're looking to develop siting policies. And we hope this planning segment will lay the groundwork for the second part of the webinar, which will focus on the details of local law and land use regulation. So as Eric mentioned, I'm Barbara Johnston, a senior planner with Labella Associates, and my specialty is working with local governments, but Labella has a lot of expertise in all aspects of solar development from the developer and the municipal side. So I learn from them about interconnection policies, interconnection feasibility, the environmental issues, and the site planning issues. So I hope to share some of that with you as far as the developer's perspective so that you have that going into your planning process. So we're going to cover how to develop goals for your community and delineating areas to site solar development, to help you understand what areas are most feasible from the developer's perspective, and balance that with where are your community's most sensitive lands so that you can use this information to set clear policies and siting guidelines that will be incorporated into your local regulations. So a solar siting goal, we're looking to accommodate solar development on those lands that are most suitable for it while protecting the resources important to your community and the character of your community. But just to set up this discussion, a little background on the solar industry. To date, according to NYSERDA statistics, there's almost 150,000 solar projects already in New York State and almost 3,000 megawatts of capacity. And you can look up these statistics at the New York Sun website. And this is a map showing where the most megawatts have been installed already. It's everywhere. Most of the projects and most of the megawatts are in the large scale projects. And when you look at the pipeline, which is those that are proposed but not yet completed, most of the capacity again is in the large scale projects. The small scale solar and residential, there's been a lot of projects completed, but when we're looking at the future and increasing the capacity significantly of electricity generated by solar, it's going to be in the larger projects. So the residential projects do keep increasing. So we do encourage municipalities to accommodate small scale and residential and rooftop in your communities, as well as small commercial, which has some opportunities. Again, they're increasing, but not as fast. But again, it's going to be the large scale. So, what is this? What does a solar field look like? So here's an example of a 2 megawatt project, approximately 14 acres. This is an example of a 5 megawatt project, about 35 acres. And then transmission scale can be up to 20 megawatts. It costs a lot. There needs to be a substation built to accommodate it. It doesn't necessarily have to rely on the distribution lines that are existing because it's big enough they can maybe build new infrastructure. But the transmission scale would be over 5 megawatts and a very large would be over 20 megawatts, again, falling into the state regulation through 94C. So from a developer's perspective, they're looking at feasibility from the electric grid as well as a feasible site. So the electric grid, the electric transmission infrastructure developers are looking for, they start with a three-phase electric in general. They're looking at the capacity of the distribution system and how close it is to an existing electric substation. These are things that you might know where they are in their community, or you might need to look them up. One of the first steps for a developer, one of the concurrent steps really, is to start the interconnection process that has to go through the utility. Each utility manages interconnections of generating facilities into their power lines so that they can maintain reliability of service. Electricity is complicated. It travels both directions along electric lines, and it needs to be managed. It needs to be available whenever someone turns on the light. So the electricity is constantly flowing along these lines, and the utilities need to manage how new internet interconnections come in, and there's enough safeguards in the hardware to keep the system safe and reliable. So there's a process. The developers need to go through the process to get interconnection approval. For the very small systems, there's an expedited process. For the larger ones, you might have heard the term CESIR review, that's CESIR, and it takes some time. They're trying to shorten the time frame to get some of these projects through, but it is time consuming. And the utility, after it gets its request, might require the developer to pay for some upgrades to the lines. So this aspect of the project is certainly on the developer's mind as they're also dealing with a site. So the site considerations that a developer considers, they do look at the zoning code. They're concerned about whether there's any regulated wetlands that would need to be avoided. They're looking at land cover, habitats, farmland, any areas of archaeological sensitivity. Topography is a key factor. They're looking for level or slightly sloping parcels. Depth to bedrock is a concern because they do drive some piles down to mount the electrical panels. and certainly shading. You can see in this picture on the right that the solar panels are shaded part of the day by trees, which affects their productivity certainly, and proximity to an airport, there's FAA considerations as well. So a developer is looking for a site that's permitted. They don't want to have delays or obstacles in the local government review. No wetlands, little impact on wildlife, not in an agricultural district. But the important ones are near a three-phase connection, gentle or level topography, and good solar capacity. The developer needs to also consider the process of environmental review. These are some of the permits required, as well as funding. And we're talking to local governments, but I wanted to give you a little background on all of the other things that developers thinking of besides the municipal permit that they're looking for. The grid connection, the site characteristics, all go into the proposed site plan that comes to your community. So when you want to plan ahead for solar development, where are the sites that are most feasible? Again, level or gently sloping slopes that are facing towards the south, large areas of open areas with few environmental constraints and close to the electric lines. If you haven't seen this tool, the Scenic Hudson Solar Mapping Tool is a great resource. Some of these layers are only available in the Hudson River area, but some are statewide. But you can look up an area to see whether it's a clear area, farmland or fields or forests. And you can also look at whether a land is level or not. So these blue are gentle slopes or level. Greens are somewhat feasible, and then this particular site is only infeasible in certain hilly parts of the town. This tool also screens for the regulated wetlands and flood zones, and you can overlay the transmission lines. So transmission lines and the excuse me, the three-phase power, the blue lines are those that have the high capacity for hosting. And this information is also available online, if not through the Scenic Hudson tool, through each utility can map the hosting capacity of the electric line. So you can do a search for that. And this is an example of a national grid hosting capacity map. It shows certain parts of the town have good capacity to supply to manage to accommodate a solar development, and others have limited capacity. And you can get some specific information about the particular line and where the substation is also. Again, this is a guide. Developers look at that at the beginning, but then they do need to do an interconnection study to find out the details and whether the utility is going to require some more upgrades. So balance where the solar is feasible with where are your community's most sensitive lands. I do a lot of work with agriculture planning and farmland protection. So if you have an agricultural or farmland protection plan in your community, you might have mapped out the highest priority farmlands. This is a map showing actively farmed lands with high quality agricultural soils that this town designated as their most significant agricultural resources. This town also had a natural resource plan done to map out some green infrastructure. So those are overlays, also areas that should have some protection in the local laws. So as a community, you need to set clear policies and guidelines to guide your regulations. For example, in a comprehensive plan, a typical policy would be encourage renewable energy, retain our high quality farmland, protect natural resources. You might consider something more focused to guide developers to avoid siting facilities on your highest quality farmland that's within a designated protection area, and to ensure that the facilities avoid impacts on your agricultural and natural resources. You might want to encourage solar facilities to accommodate some agricultural uses. It's not traditional agriculture in some areas to have sheep pastures or herbs, but it's an opportunity to make use of the land that's being developed for solar for some agricultural or agriculture compatible uses. And the siting can also avoid fragmentation of agriculture as well as natural lands. And siting can also help screen views within designated view sheds. It's another feature that you might have mapped that can be part of your solar siting policy. So that's a summary of the policies. I think I have a little time to talk about the agricultural concerns, because this is something that's certainly on New York State Ag and Markets mind, as more and more solar facilities are sited on farmland. When the project is in an agricultural district, the developer needs to submit an agricultural notice of intent. And this is triggered by the NYSERDA involvement with funding. And the intent is to avoid the impacts to farm operations. So Ag and Markets has guidance for how the facilities are constructed, restored, and monitored, and decommissioned. They're pretty clear guidelines, similar to with pipelines, that when you remove soils, you need to store it and put it back in the same profile that you took it out, so the topsoil stays on the top, for example. Burying the cables more than 4 feet deep so that farms can be above ground and not just can continue to be farmed above the cables. Place the overhead lines at the edge of the fields, again, to avoid the fragmentation and to prevent livestock from wandering into the field. And then the restoration, drainage patterns are important, the access roads. These facilities might be in the ground for 25, 30 years, but the farmland should not be disturbed. And if it's done properly, you can minimize the chance that this farmland would be less productive after the facility is decommissioned. And there's a process of inspection during construction that is important so that these guidelines are followed carefully. And again, in decommissioning. I just want to quick walk through one example of a project site. This happens to be in Chautauqua County. This site had some wetlands. It was on a road. There was a house nearby and a stream. When the developer first looked at this site, the first thing they do is how many panels can we fit on a site? So this was the first stab at it. They basically packed the site full of solar panels, except for the regulated wetlands. After working with the municipality, they went from the 10 megawatts to a smaller project, which worked for them in their financial model, fortunately. But the design was changed to avoid developing along the roadside so that the visual impact from the road was much less. There's a creek and a wetland separating the road from the panels as it was ended up. This configuration for this developer was able to be feasible financially. Some developers might have walked because they couldn't build as big a project, but so every project is different and there's a lot in play as far as what's feasible from a financial point of view as well as a site point of view. But there is some give in the site review, and this project, fortunately was able to come to a nice conclusion for the community. So again, it was proposed to 5 megawatts, and then they did have an access road and batteries with the screening, and they avoided doing the wetlands. So just in summary, when you're looking at projects, and these will be addressed in the local law section, you want to look at the size of the project, the coverage, screening, agricultural resources, safety and decommissioning. The views can be modeled through a line of sight analysis, and you can require some screening for the visual impact. And even a view shed analysis, which models where the project could be visible. And just a small section on the battery storage. This technology is evolving so quickly, but most projects do include battery storage because it gives them some incentive it gives them some financial advantages to have some battery storage, because if you think about it, when a solar panel and a cloud goes by, it stops producing. If you can feed the electricity into a battery storage system, you can dole out the electricity to the grid in a more managed way. And you can also have a few more hours of sunlight that you can produce, and again, dole that out into the grid in a managed way. It's a helpful project to have as part of a solar development, and many of them are including that now. But obviously, there are some considerations for the project review, including safety and screening, emergency operations, and the decommissioning. So I'd like to just share some resources. NYSERDA's Solar Guidebook is a good overall resource, gives a lot of information, and there's also a guidebook on battery storage in particular. I'm sure those will be updated as needed and the technology changes. That was a lot in a quick amount of time, but I'll be available for questions, I think, after our program.
Absolutely. Thank you very much, Barbara. That was very informative. I enjoyed seeing the scenic Hudson map. That was really neat. We are getting some questions. We're going to hold off and pose those questions at the end, but feel free to shoot your questions into the chat section, and we'll make sure we'll get through as many as we possibly can. Up next, we're going to hear from Greg Scholand and Allison Bartlett. They are both from Harder, Seacrest, and Emery. Greg is going to go first. He's going to pass it off to Allison. So let me just introduce them quickly to you. Their full bio will be in the chat. Greg is a land use attorney who advises businesses, landowners, developers, municipalities, and public authorities on a wide variety of zoning, land use, and environmental matters. His experience includes assisting upstate New York towns with drafting, revising, updating, and administering their local land use and zoning law regulations. And Allison is an environmental land use and zoning attorney. Her experience includes assisting municipalities with drafting and revising local laws and zoning regulations, negotiating solar agreements, and assisting businesses with permitting and regulatory compliance and environmental land use litigation. So with that, we will go to Greg, and Greg will pass it on to Allison.
Good morning, everybody, and thanks, Eric. I'm going to start my screen share. Oh, just start at the beginning. Okay, so Allison and I are both land use attorneys, and we are going to talk about sort of what the town can do in preparing a solar law, or if you have a solar law, kind of revisiting and updating it, with the goal being essentially to have it do all the things that you want it to do and not to have any sort of unintended side effects. So that's what we think of when we think of kind of getting it right and having kind of smart solar regulation at the local level. So this is an overview of what we're going to talk about, but I won't read what's all on the slide. I think we'll just dive right in. And a couple of initial notes. We're going to use the term town when we're talking about the municipalities that are making these decisions at the local level. That's really just shorthand for municipality. New York State has 3 types of municipalities: towns, villages, and cities. We have no unincorporated areas, so you're always in one of those when you're in New York State. But just municipality is a long word, so to make the conversation a little easier, we'll just say town. And also just the way that New York, it tends to be structured, most of the solar land where the large farmland parcels are tend to be in towns rather than in cities or villages. But we mention that just because if you're here representing a village or a city, what we're discussing still applies to you, even though we're going to be saying towns. And like I think Barbara mentioned, there will be a Q&A at the end of the webinar, but we also are happy to field questions afterward. If you think of something later today or a week from now, please feel free to reach out, because we enjoy talking about this stuff, and kind of that's why we do this. So there are three basic categories of solar development, and they're broken down by size, and Barbara touched on this a little bit. We're going to be focusing on that middle category today, the residential size ones, which are the smallest. That's your typical rooftop or building integrated installation, or maybe a single panel that's ground mounted in a residential backyard. The typical scenario with those is that they are for power to be consumed on the premises, and they generally don't require sort of substantive review at the local level other than a building permit, because those are regulated by local building codes. So in your solar law, you can specify that if you're below a certain threshold, or if it's a residential scale project, that those are kind of exempt from any further review. The main category we're going to be talking about today is that middle category of commercial scale solar farms. Typical size for this is in the 10 to 100 acre range, although that's not sort of hard and fast rules. That's just what you typically tend to see for the sizes of these projects. If you take as kind of a general rule of thumb, which has changed over time, how many acres it takes to get a megawatt of electricity, the current rule of thumb is somewhere in the neighborhood of 5 acres per megawatt, and that has changed as the technology has improved. It will probably continue to change as the technology improves. But if you think of the 10 to 100 acre range, that gives you a 2 to 20 megawatt range. And once you get above that in size, if you get to 25 megawatts or above, that takes you to the third category, which is the utility scale projects. And those are not going to be our focus today, because they generally are regulated at the state level rather than the local level, although there are some opportunities for local input, and Allison is going to be talking about those in a little bit. That's through the 94C process, which is the 94C is a section of the state executive law that basically gives the state, through that Office of Renewable Energy Siting, sort of the authority to make decisions that for smaller projects get made at the local level in terms of where they're going to go and what they're going to look like. So if we focus on that middle category of the commercial scale projects, there's really two main mechanisms that towns can use when they are going to be regulating these things through a local solar law or a land use regulation. And they're not that much different, but just to briefly cover them, if you have an existing zoning code or a set of land use regulations, a land use ordinance, it's common that a new chapter or article or section of that code will just be created that addresses solar development. So the benefit of having it built into your zoning code is that it's easier to make cross references to things that you want to be kind of generally applicable, like maybe a review procedure or the enforcement mechanisms for non-compliance. So it's easier to do that if you have your solar law essentially built into your existing zoning code. But if a town does not have a zoning code, or if for whatever reason it wants to, it can pass a standalone local law. And the main benefit there is essentially just that you have everything kind of self-contained in one document, and someone looking to sponsor a project can look at the solar law and kind of see all of the requirements that could apply all in one place. But the concept is essentially the same. It's where you're putting your set of rules that will govern these projects when a developer wants to put one in your town. So if we dive into kind of the key components of your solar law at the local level, the first kind of large scale decision is where are the projects going to be allowed? And here's just an example of a zoning map. And the typical way it works is you would select zoning districts and say, these are the districts where solar development is permitted. Logical fits in most towns are going to be your agricultural district, because that tends to be where the large parcels of open farmland are located. So in this map, that would be the white district and the peach district. Industrial districts are also commonly places where solar can be allowed in a town. And the reason for that is, for one thing, you often will have, like you see in this one, some large parcels in industrial districts. And also, by the nature of an industrial district, people tend to be less sensitive to visual impacts, because you expect to see industrial development in an industrial district the way that maybe you don't in an agricultural district. But let's say you have a map like this and a town wants to allow solar in basically most of their land area. So right, the white area and the peach area and the gray area, the ag and the industrial districts, but maybe they have some specific resources that they want to protect in terms of visual impacts. A great tool to do that is an overlay district, which basically allows you to say, yes, these zoning districts can have solar development, but in specific areas, we're going to impose additional requirements or have just outright restrictions on that type of development. So if you look at this map, picture that the green community facility that's zoned there toward the middle of the map, let's say that that's a public park or a scenic area that you want to give special protection to. If you apply an overlay district to it, it can look something like that. And the idea is basically it allows you to customize where these projects can go and give a little more protection to particular resources. Again, it's usually something like a scenic resource or maybe a historic neighborhood or something where the town just kind of makes the decision that it wants to get a little more granular in terms of where these projects can go. That kind of feeds nicely into nuisance abatement, which is one of the major concerns with practically any kind of land use regulation, like how do we reduce conflict between neighboring uses. And setbacks or yard requirements are sort of one of the most common methods for preventing that type of conflict. If you have a zoning code or land use regulation, you're almost certainly familiar with these. The concept is just you can't start building whatever you're building until you're a certain amount setback from the property lines. Setbacks and making decisions for solar, you can look at what else you have in your code in terms of setbacks for other commercial or industrial uses to kind of have a frame of reference for how wide a setback the town has decided is required for other types of uses. And the point of the setback in large measure for a solar farm is just to reduce the visual impact. But it's important to remember in choosing the size of setback areas that it can really impact how much of a parcel can be developed, and that can essentially have the effect of meaning only larger parcels are really suitable for this kind of project. So if we go to just a simple example to illustrate that, let's say you have a parcel that is 1,000 feet by 1,000 feet. I understand in real life, most parcels are not a perfect square like this, but like most lawyers, I'm not good at math, so I like nice round numbers. So that parcel, it's a perfect square, would give you about 23 acres. And if the town imposed a 100-foot setback on solar development, you apply that to all four sides. Now, in practice, sometimes yard requirements or setbacks are not the same for all four sides of a parcel. They can be different for a front yard and side yards and a backyard. But just for the sake of the illustration, if we say 100 feet all the way around, then for your 23-acre parcel, only a little less than 15 acres of it would be developable based on that setback requirement. So about 36% of that land area would essentially be taken out of the area that the solar developer can use. Now, obviously, that percentage is going to change as the parcel gets larger. So it's not saying that it's always going to be 36% or anything like that. It's just worth keeping in mind that as your setback area increases, it will have the practical effect of only larger parcels are going to be attractive for this type of project. Similarly, if a town wanted to say, well, we like solar, we're pro-solar, but we are concerned about people complaining about visual impacts or just impact on neighboring properties. So let's go to a 200-foot setback. And this illustration just gives you a sense of how that can impact how large a parcel you'd need to really have a big enough developable area, because a 200-foot setback all the way around on a 23-acre parcel would take almost 2/3 of the land area. So it's not necessarily a bad thing to say 200 feet is what we want as a setback. The town just wants to make it as a conscious decision and kind of be aware of the impact that it can have on where these projects can be located based on the size of the parcels. If you want to customize setbacks so that more land is available for development, but you're still protecting kind of the more sensitive uses, one option to do that is you can customize a setback based on what the adjoining use is. So in this example, you're having a 100-foot setback going all the way around the parcel, but you can specify that if the adjoining use is residential, the setback increases to 200 feet. And that kind of, it's almost like a compromise where you say, we're not going to take as much land out of what can be developed for a solar farm on an individual parcel, but where it could have sort of a greater impact on the neighboring use, like if it's residential and it's someone's backyard, we're going to give a little more protection to that adjoining use. Similarly, you can do that with scenic resources or other things that the town just wants to protect. Similarly with the same concept really as the overlay district. Idea is if you have a lake, you can say the setback is an additional distance from a lake or a forest or a similar resource like that, as compared to if it's just next to another farm field. Barbara talked a little bit about visual screening, and that really is very important for local solar laws. And if you think about it, solar projects are really good neighbors in most ways. When you think of most of the causes of nuisance, like noise or light pollution or odors, you don't really have, or traffic for that matter, you don't really have that with a solar farm once it's up and running, right? Because it's basically the panels are in the field just collecting energy, and it's very quiet, and they tend to be good neighbors. But when you see resistance to solar projects, it is often people are concerned about how it looks. And if you live out in the country, you generally want to see open fields, and people like the kind of rural character of their neighborhoods and don't want, or at least are kind of resistant to or skeptical of the idea of covering 20 acres or 50 acres with panels and metal. So while it might seem sort of trivial, like, okay, well, what are we going to do? Plant rows of trees or bushes? Like, that really is something that you want to think hard about in your local solar law, because it really can be the driver of some of the resistance if the way that the site looks just makes people uncomfortable. So the goal of the screening is obviously just to reduce the visual impact of the installation and the fencing that's around it, because almost always a developer will put a security fence around their installation. And I mentioned this last point, expect developers to choose the lowest cost screening option that'll meet their requirements. That's not a bad thing. Like, that's just how businesses in all industries tend to operate. If they don't want to spend $2 if they can spend $1. So the reason that that's worth keeping in mind is that the devil really is in the details in terms of what the vegetative screening requirement in a local solar law looks like and how effective it is. I have seen some that are kind of on the less specific end of the spectrum that just say we require a landscape buffer or a vegetative buffer. And the problem with that is that it doesn't really give the town kind of a standard for enforcement to say, hey, wait a minute, you planted a row of bushes or trees and they're too far apart and they haven't grown, so they're not really providing any screening effect. Well, if all the code says is that you need a landscape buffer, it's landscaping and it's between the adjoining properties and the property lines and the solar panels, so they're not technically violating anything if they just say we planted them and we're hoping that they continue to grow. So if you want to be more specific to give the town a little more opportunity for enforcement, something like, which I've seen in a local code, a berm, landscape screen, or other opaque enclosure. That's better because opaque enclosure is essentially, it's a standard that you can apply to any given site. Like, opaque has a specific meaning. It means you can't see through it. So if the vegetative screen just isn't accomplishing its effect because you can be at the roadway or at an adjoining property and you can easily see the site, gives the town a little bit of a lever to say, wait a minute, you're not complying with our code and we need you to do something more. On the more sort of specific end of the spectrum, if you want to be a little more robust in what you're requiring from an applicant, there are some towns that require a landscaping plan that gets even into the details of what they're going to plant, how far apart they're going to be, how big they'll be at the time that they are planted. Those kinds of details can really make a difference in terms of making sure that once those plants and that screen gets established, it's going to have sort of the aesthetic effect that you want, which is it provides the shielding that tends to make these projects less controversial and just improves the overall appearance of the area where they're located. So moving on from visual screening, protecting the town's resources is obviously a major consideration. And one of the things that your local solar law will want to consider is how can the town's roads be affected by these installations? If you think of where solar farms tend to go, They're out in rural areas that might have roads of varying quality. Some might not be asphalt, they might be gravel, or they might be dirt roads. And while the solar farm, once it's installed, does not have much traffic associated with it other than maintenance work, the construction phase can be pretty traffic intensive because you have a lot of equipment being brought in and employees coming in to do the construction work and install the panels. So your local law can include some roadway preservation provisions. And some of the things that they'll commonly require is some kind of documenting of the road conditions prior to the installation with photos or video. And then that can be compared to the conditions once the project is installed to see if there's any sort of apparent degradation of the roadway that you could attribute to the installation work. Another thing that they can require in a local law is some sort of financial mechanism or a bond to cover roadway repair if there is damage during the course of the construction. And it also gives the town the opportunity, if there's roadway preservation provisions in the town code, to have a discussion with the developer during the application process and say, here are the routes that we would like the construction traffic to take. And again, the idea there is just to protect the town's resources. If you have some dirt roads that might be a more convenient route for the developer, but that are more likely to get degraded or cause traffic problems, then you can direct that the traffic take a different route than that during the construction phase as part of the project review in an application. Decommissioning, Barbara talked about a little bit, and Allison is going to be discussing this in more detail, so I won't discuss it here, but the concept is really just you want the town to be protected if something happens to the developer during the life of the project, so that the equipment doesn't end up being abandoned on the property and then sort of the town is left holding the bag. So there are mechanisms to protect the town from that kind of scenario. Another thing that you'll want to think about in your solar law is just kind of the administration and the enforcement, kind of how it's going to look when someone applies for a project. And that's which towns are going to, or which boards are going to review it, and which specific people in the town. You know, do you want the highway superintendent and maybe the town fire chief or town engineer to be signing off on every project? So it's just something you want to think about in terms of what the flow of the application will be. Seeker review is another thing that will be required anytime there's discretionary approval coming from the town for a project, which is common because these commercial scale projects will usually require at least site plan and maybe a special use permit, depending on what the town decides. Allison is going to talk more about this administration and enforcement kind of angle of local solar laws, so I won't go into detail on that. But after the installation is complete, you probably also want to build in periodic inspection because, again, particularly for things like visual screening and making sure that the site's being maintained, you want someone, typically a code enforcement officer or a building inspector, to be able to go to the site and say, okay, this looks like it should, or the developer needs to do something more to make sure the site's being properly maintained and looks the way that it should. Same with enforcement. A lot of times it needs to be in there so that the town has a lever to make sure the developer is maintaining the property and doing what it should. A lot of times this is borrowed from elsewhere in a zoning code or land use regulations, kind of what are your standard provisions for violating any of the provisions in the zoning code. If that sounds like a lot, and it is, and that's not everything, those are just kind of the key considerations to doing these things the right way. It's good to know that you don't need to start from scratch when developing a local solar law. You can look at laws in neighboring municipalities as starting points. And another option is NYSERDA, the New York State Energy Research and Development Agency, has published a model solar law that essentially has done a lot of the thinking for you in terms of what provisions you want to have and kind of a logical framework for them. And I'm now going to turn this over to Allison, who is going to talk about the model solar law and a few other considerations related to this type of project.
Great, thank you so much, Greg. If everyone can bear with me for just a moment while I pull up my slides so that I can begin screen sharing. Okay. So just backing up a little bit before I get back into the NYS Model Law that Greg just mentioned, I just wanted to provide a high-level overview of the 94C process. So as Greg mentioned earlier, the large-scale solar projects, those that have 25 megawatt capacity or more, they're governed by the state 94C process rather than local procedure. So although the permitting process isn't governed by local procedures, towns do play a limited role in the process. So for example, applicants are required to consult with the town related to the procedural and substantive requirements of any local law before submitting an application to the State Office of Energy Siting. When a town does receive notice of filing up an application within their jurisdiction, the town's required to submit a statement to the Office of Renewable Energy Siting, indicating whether the proposed facility is designed to be sited, constructed, and operated in compliance with applicable local laws and regulations, if any exist, concerning the environment or public health and safety. The Office of Renewable Energy Siting will also publish draft permit conditions for public comment related to any project subject to the 94C process. And the public notice requirements includes giving written notice to the town. So the town will be on notice of conditions related to any project that may be coming to their town so that they can provide public comment during the comment period. And if the town indicates that the proposed facility isn't designated to be sited, constructed, or operated in compliance with local laws, then a hearing might be held. And just as a reminder, as Greg said earlier, I'm using the word town just like Greg did, instead of using the word municipality, but the same process would apply to both villages and cities. So this is just a really high level summary of this process. And the main takeaway is that the 94C process really supplants the local procedure and approval process. And it also expressly states that a town may not require any approvals, permits, or conditions related to the development, design, construction, operation, or decommissioning of a major renewable energy facility except as set forth in 94C. So the next step, diving back into the commercial projects under 25 megawatts that are subject to local procedures and policies, I just wanted to turn back briefly to the State Environmental Quality Review Act, SEQR. So SEQR applies whenever there's a discretionary approval where a local government agency must approve or fund a project, or where it directly undertakes an action. So thus, whenever a town's involved in approving a solar project or directly undertaking a solar project, SEQR is going to apply. And SEQR addresses the environmental impacts of a project, such as it broadly addresses environmental impacts. Some of these include aesthetic impacts, traffic impacts, impact to the community. That's just to name a few. And at a high level, SEQR classifies actions as either type 1, type 2, or unlisted actions. And solar projects can fall under any of these three categories. So type 1 actions are those that are likely to have at least one significant adverse environmental impact. Type 1 actions are laid out in the state regulations, but local agencies can also add additional actions that they believe to be type 1. Type 2 actions are those that have been determined not to have a significant environmental impact on the environment or are otherwise precluded from environmental review under applicable state laws. And then unlisted actions are all of those that are not specifically identified as either type 1 or type 2. So as it relates to solar projects, I wanted to just give some examples of type 1 and type 2 actions. So the first example is that projects involving the physical alteration of 10 or more acres are generally type 1 actions. Now that's not specifically to solar, that's a general threshold. But as you'll see in a minute, there's certain type 2 actions that even though it involves a disturbance of over 10 or more acres, it won't fall under the type 1 category and is instead qualifies as constitutes a type 2 action. And the Another note that I want to make while we're talking about adoption of local laws or zoning code amendments, the adoption of changes in allowable use within any zoning district, if it affects 25 or more acres of the district, the action of changing the zoning rules itself is a type 1 action, so triggers the review required under type 1. So even though it's not a project itself, the decision to make the zoning change can be a type 1 action. And then, like I said earlier, additional actions as determined by the local agency might be type 1. Examples of type 2 actions, and these are laid out in the state regulations. So installation of solar energy arrays on most existing structures are going to be type 2 actions. There's certain limitations. These limitations are generally related to listing or eligibility for listing on state or national preservation historic registries. Another example of type 2 are the installation of solar energy arrays where the installation involves 25 acres or less of physical alteration at certain sites. So the certain sites that are listed there are closed landfills, parking lots or garages, currently disturbed areas at publicly owned wastewater treatment facilities, and currently disturbed areas at sites zoned for industrial use. Another example are sites that have undergone cleanup programs under state oversight that have received certificates of completion. Some of those may constitute sites that may fall under this type 2 action for purposes of seeker review as well. So the main takeaway here is that even if the project involves more than 10 acres, it would ordinarily be a type 1 action. There are certain sites for solar projects that can constitute type 2. So now diving into the NYSERDA model law. So just as an initial matter, municipalities, towns are expressly authorized to adopt legislation related to solar projects, and the NYSERDA local law or model law provides a really good base to start off of. It gives towns the opportunity to pick different examples that may fit best for that community specifically, and it also provides some commentary giving an explanation as to why the model law proposes certain provisions a certain way. And this can be found on NYSERDA's website. So just by searching online with NYSERDA, you'll be able to find this. So just at a high level, the different sections addressed in the law: authority. So like I just mentioned, the authority is going to be derived from state law, allowing a municipality or a town to issue its own local law governing solar projects. The statement of purpose, I'm going to discuss this a little more on the next slide. Definitions, this seems pretty straightforward. The only reason I'm bringing it up here is going back to what Greg said, just considering whether this is a standalone local law or if it's going to be added into an existing zoning code. We'll want to make sure that cross-references are consistent and that terms, there's no conflict between terms. So applicability, again, note that projects subject to 94C are subject to the state citing process rather than local policies. And then permitting requirements. The model law separates solar projects into 3 tiers when suggesting different permitting requirements. The first are building mounted. So think of the solar arrays on a residential structure. Ground mounted systems that are used primarily for on-site consumption. So generally going to be these smaller ground systems. And then the third category are all others. So think of the larger scale systems that are primarily for both on and off-site consumption. The model law gets into abandonment and decommissioning provisions, and then also enforcement. And it gets into more than this, but I'm not going to take up everybody's rest of their day by going through all of the different provisions. So this slide, I just wanted to provide 2 different statements of purposes. One's from the City of Auburn's code and one's from the Town of Alden zoning code. The statement of purpose, that's going to think critically about what the benefits for the community are. The purpose is really going to depend on what's best for the community. And so I just wanted to provide both of these to show that there's really no wrong answer for purpose. It can be general with specific purposes outlined, but these are two just pretty good examples of what you might expect to see. So applicability, the model law suggests that adding provisions that any project must comply with applicable codes, industry standards as referenced in the state building code, and then also the state energy conservation code and any local codes. It also suggests reviewing any local zoning for any conflicts. So for example, consider whether an existing code prevents an accessory use from existing on an accessory structure. If there's provisions like that in an existing code, that would theoretically prohibit a solar panel from being placed on a shed. So an accessory use, the solar on the accessory structure, a shed. So it's just one thing to consider, looking critically at any existing code to see where there might be a conflict, and then work on drafting to prevent any sort of conflicts from coming up. So, as will likely not come as a surprise, the model law proposes more robust permitting requirements as the project type and size increases. So the first category that's discussed in the model law are these roof-mounted systems. Requirements related to these systems generally deal with aesthetics, such as design, glare, and height requirements. The glare requirement that's in there is a requirement for panels to contain anti-reflective coating, just to minimize glare that might come off of the panels. The next category that's discussed in the model law are these ground-mounted systems, primarily for on-site consumption. There's a few additional considerations for these types of projects. One of them is, where can the system be located? So not just getting into the setback that Greg talked about earlier, but where on the property can the system be located? So for example, a town might consider not allowing a solar array to exist in the front yard. It might require them to be just in the side or the backyard, and depending on the district, maybe that could change depending on the density of the district. And again, getting into the height limitations, screening, and lot size, and Greg provided a good summary of the considerations that a town will want to make when determining what sort of screening requirements to put into a local law. So then the model law has several more permitting requirements for this tier 3 category, which are all others that aren't the two that I just mentioned. So thinking about these larger ground mounted systems that are used for both on and off site consumption. So these are where we're most likely getting at the larger multi-acre projects. The model law sets forth an application procedure that includes review by the board or code enforcement officer for completeness, and proposes a time frame for requiring the board or code enforcement to act on determining completeness of the application. One thing to consider is, I believe the model law suggests having the board or enforcement officer determine within 5 days of receiving an application for completeness, but you may want to consider additional timeframes just depending on when boards regularly meet, if it's going to be decided by a board rather than a code enforcement officer. There's several site plan application requirements outlined in the model law. A lot of these are things that have been discussed already, so I won't get into too much more detail here. A permit condition may be the requirement for a property maintenance an operation plan. So think of upkeep, mowing requirements, just to minimize visual impacts as the lifeline of the project continues on for several years. Again, a lot of the same requirements that we talked about earlier, and signage and lighting. So municipality or town will want to think about what kind of signage may be allowed in the zoning district generally, but also as it relates to the project. And then lighting, this goes back to nuisance abatement. So considering lighting and restrictions on lighting to the extent reasonably practicable to still promote safety, but avoiding any interference with neighboring properties. And then another consideration is tree cutting. So when discussing the screening requirements, obviously it's critical to these solar arrays that they have minimal interference from foliage. So just think of any trees and tree cutting requirements, and also as it relates to screening requirements. Now, decommissioning requirements. Decommissioning is the process of removing an abandoned system and restoring the land to its pre-project condition. And the model law proposes that a applicant issue a bond for 125% of the cost for removing the system. This just gives the town some security in the event that something happens to the project and that something happens to the developer. So there's some security backup in order to restore the site, like Greg mentioned, so that it just doesn't sit abandoned and become an eyesore over years. Oops, going back. So review and enforcement, Greg pretty much covered this. Consider what board is responsible for review within the town. Different boards may be authorized to issue special use permits, and different boards may be authorized to issue the site plan approval. So just something to think about when drafting the local law. And enforcement, the model law provides that for any violation of the local law to be subject to the same enforcement requirements as provided in local zoning and land use regulations. So review policies to see who's responsible for enforcement and consider if you want to change anything. So, and I think Greg covered these, just examples of where you can look. There's a lot of resources online. You don't have to start from scratch. Like he said, the NYSERDA model is a great resource. There's local codes available online. And then you can also search the Department of State local law database and restrict by year so that you can see some recent examples of what some of your neighbors have done. And just quickly to touch upon, now, a lot of towns might own property themselves, so there's an opportunity for actually for getting solar projects onto town-owned land as well. So just at a very high level, there's two main types of agreements. One will be a straightforward lease, and one is a power purchase agreement. So depending on the desires of a town, it'll take serious consideration in determining which type and structure of agreement will be best. A lease generally provides for standard revenue through lease payment, whereas the power purchase agreement, the revenue stream is dependent on the power generated. Selection of site. So one type of site that may be attractive for a town is a closed landfill, and that goes back to the type 2 action that I discussed earlier. But you'll want to be sure, if that's a site that you're looking at, to check any sort of restrictions that may be in place for use of the property, such as through a site management plan, any closure documentations, any deed restrictions are in place. So just there's some due diligence that needs to be done in looking at the type of sites, but a closed landfill can be an attractive site for these kind of projects, since they're generally limited to what they can be used for. And then there's always the procedural considerations that towns need to have in mind, because the conveyance of for example, the conveyance of property, such as the leasing of town-owned property, is subject to a permissive referendum. So a town will just want to be sure to remember to build these timeframes into any projects that they look into on town-owned land. And then with that, I'm just going to flip this back to Greg for a few minutes to discuss some of the real property tax law implications.
Thanks, Allison, and hi again. We decided to put this at the end of our section of the webinar, basically because we think important for towns to know about, and this real property tax law section has some misconceptions or sometimes is a source of confusion, but it's kind of separate from the local zoning considerations and preparing a local zoning law. So we wanted to get through all of the other things you just heard before just covering this in a couple minutes. The real property tax law, section 487, is basically a state law that is intended to incentivize renewable energy development, and solar specifically is included in it. And the basic mechanism is that once a solar installation is put on real property, in the first 15 years after that installation, the increase in value that's attributable to the solar installation is essentially tax exempt. And you think of the way that that works in practice. If you have a parcel of land that's worth $100,000, let's say, when it's just vacant land, and suddenly a solar farm is put on it, and now, again, just to pick a number, let's say now it's worth $2 million because those panels are fixed to the real estate, so they become part of the property and they're generating income, so it's going to increase the property value. So in a normal situation, you increase the value of the property from 100,000 to 2 million, its assessment goes up, and then the tax bills go up for that property. Well, the state wanted to incentivize the building of solar farms, so they say for the first 15 years after that installation is put in, the property is still taxed as if it were valued at $100,000. So the assessment changing because of the increase in value does not affect the tax bills for the first 15 years. If a town wants to, they have the opportunity to opt out of that tax benefit, and they can do that by passing a local law or a resolution, however they ordinarily take action as a town governing body, the town board. And then you have to file a copy of that with NYSERDA and with the State Department of Taxation and Finance. And essentially, when you make that decision, then if a solar project is installed in your town, then right from year one, that increase in the assessed value of the property that's attributable to the solar farm would be added to the tax base for real property taxes. So we want to go through just a quick example of kind of how this works in practice, because sometimes it can have unintended consequences with what a town decides to do. So if you picture 3 separate towns, let's say the first one has made the decision kind of as a matter of town policy, we are pro-solar. Their decision is easy, right? They will not opt out. The default rule is that if you don't do anything, then the tax exemption applies. So they don't opt out. And the result of that, if we can go to the next slide, result of that is that they're more likely to attract solar projects. So for those first 15 years, the solar developer, his project is not subject to the real property tax. And this is an important point, that solar developers are, I think, in practically every case, the ones that are going to be responsible for that property tax under their agreement with the landowner. Because if the landowner was responsible for the increase in property tax, it would basically remove most of the incentive for them to lease their property to a solar company, because they'd be paying a lot of what they make in the lease income in their increase in property taxes. So it is the developer that's kind of making the financial decisions based on, at least in part, what the tax situation is going to be at a particular site within a town. So let's say you have town number 2 and they've made the opposite decision. They say, we are anti-solar for whatever reason, just don't want these projects in our town. They also have an easy decision, right? They would opt out and the tax benefit isn't there. And the practical effect of that is that they're less likely to attract solar projects, because a developer is going to look at the tax situation in each town where they're thinking of sponsoring a project, and will generally gravitate toward the towns where they get this tax benefit, because it is a very powerful incentive for the finances of the project. It's just kind of making the numbers work. So the third town, let's say that they're pro-solar, but they say, well, we want the tax revenue right away. We like these projects, but we think if they're coming into our town, we want that tax revenue. So do they opt out or not? There could be a temptation to opt out and think, well, we'll still get the projects, but we'll get the tax revenue earlier. But the practical effect of that, if we can move ahead, is that they are less likely to attract the projects in the first place. Because again, a developer is going to look at these front-end tax considerations very carefully when they're making decisions about site selection, because it really can make a big difference in terms of whether a project is viable. So if you think about going ahead 16 years after the tax exemption period is up, Town 1 is now getting the tax revenue. And in the meantime, they could also be getting additional revenue. They don't have to wait 15 years before they get any practical benefit in terms of sort of financial income from a project, because there can be pilot agreements during the 15 years. And Mike from Labella is going to discuss those in just a minute. But towns 2 and 3 are less likely to see that income because projects are much less likely to end up in their town if they have opted out of the 15-year tax exemption. So it's just something to think about, because sometimes a town thinks they're making the decision, do we want the tax revenue if they opt out? But the practical effect of that decision really can be that they're deciding, do we want solar projects, just because of what a powerful incentive it is. And because the sun shines everywhere, a developer is going to look for that tax benefit when they're deciding whether to site these projects. So that's everything I have. And I think we're now going to turn it back over to Eric, who will introduce Mike.
Thank you so much. Yeah, next is Mike Coakwhite. Mike is a partner with LaBelle Associates, where he focuses on supporting municipal and nonprofit clients. In his role, he specializes in assisting solar developers with applications for assistance from county IDAs. These applications center around pilot agreements, but can also include sales tax and mortgage tax assistance. So we'll pass it over to Mike.
Thank you. It's loading up right now. I see so many good questions teeing me up here from everybody. So I wanted to start off with a poll, if we could quickly, just to get kind of a basic understanding here of where people are coming from. And I promise, I know we're short on time here. It's only be about a 5-minute presentation. And then we want to open up for lots of questions on everything we've talked about in the webinar here. So are we able to pull that? Perfect. So question here is regards to pilots, kind of get a base understanding from the group here today. What do you know about the pilot rate? So in your community, do you know which category you fall into? Less than $3,000 per megawatt, in the middle range, over 6,000. We don't have a rate. I have no idea what this means, or what is a megawatt. So if we go ahead and hit that, and then we'll see how that turns out. So Greg, thank you. Excellent job talking into where the tax law sits. And then my contribution here is, what's a pilot? So a pilot is very high level, oversimplified. It's an agreement between that community and the developer. And that agreement allows, during those first 15 years, or some other circumstances we'll get into later, but generally speaking, those first 15 years, to make an annual payment to that community via either the town or the school district or county, how it's set up, to assist with that lack of tax revenue. We've talked in depth and very well about Real Property Tax Law 487. Again, the pilot works with this law. It's a requirement that the developer has to contact those municipality entities when they are interested in developing that site, and offer to come into an agreement of a pilot. Now, if you do opt out, this doesn't apply. So this is only for those communities that stay opted in. We talked briefly, and I just, again, high level, should we opt out? If the community does opt out, obviously much less attractive to these developers. They're looking for this incentive. It's many times required by their finances. I think strong incentive is a good word, but I'll just say it from the developer's perspective. Many times they need this pilot agreement, or I should say they need that tax incentive in order to make the project work financially. So if you stay locked into the Real Property Tax Law 487, you don't opt out, you do have those options of requesting a pilot, and you become more attractive to these projects in your community. I get this question a lot, and I want to jump at it. Are there ways around the opt-out? Well, there's kind of two things you can do. One is working with an industrial development agency. This is a great opportunity if you want to have a longer term pilot, and that's something that's of interest to the developer. A lot of times these sites will last 20 or 30 years. So having a 15-year incentive, the finance numbers don't work out. So that's one option, and IDA can work with all three entities and the developer and kind of be that middle ground in order to make some more flexible arrangements in the pilot agreement. Now you can opt back in if you've opted out. This isn't something I would recommend as far as opting in, opting out on every project, because that kind of goes against the law, and I'll let your attorney speak to you on the legal implications of that. But if you change your mind and you are opted out and you decide, you know, we think we have a good solar law in place now, we think we're in a place where we're ready to attract these solar projects to our community, then opting back in is also an option. As far as some information to wrap your head around the real property tax law 487, here's the link there. Pilot guidance from NYSERDA is excellent. You can read through there and see what the implications of actions are, how that relates to your solar laws. And for a full list of opt-out communities, there is the list here from NYSERDA. Once again, if you do opt out, there has to be a municipal resolution, and then you do have to give that information to NYSERDA so that they can spread that on via this site. Any specific questions, we'll take those now for everything, but please feel free to reach out to myself here at Labella if you have any questions specific to pilots that you might want some guidance on. So I went real quick there because we want to have as much time as possible for questions. And I'll switch it back to Eric to let that happen.
Great, Mike. Thanks so much. And Barbara, Greg, Allison, and Mike, thanks so much for this presentation. It's been very, very informative. Let me just get some housekeeping out of the way, and then we're going to dive into questions. Number one, please go to our website, usesusa.org, and check out the municipal toolbox resources. I think it's something that'll be very helpful for a lot of the folks who are on this call. Again, we have training certifications for municipal employees. We'll put that back in the chat, but if you have any questions, please feel free to email us. Email Eva, eva@usesusa.org. We're going to be sending a survey at the end of the webinar. We ask everybody just take a moment, let us know what you thought of it, and please provide us some thoughts on topics you would like to see us cover in the future. We're also going to put up a slide with all the presenters' emails. So if we don't get to a question, feel free to email them, but please keep the chats, the questions coming in the chats, because if you have a question, the likelihood is there's probably 2 or 3 people on the webinar who also have questions. So we'll go through a lightning round questions. Let's see how many we can get through. We have a bunch. First one goes to Barbara. Simon asks, can you talk about the tax on developers if the ag land is used for solar? Who gets the tax revenue?
Yes, I saw that. Thanks. I think you're referring to developing property within an ag district. So if the farm property had been receiving an ag use exemption, there's a penalty which rolls back the previous taxes saved over the last 5 years, and it goes to the taxing jurisdiction. Typically the town would be the main point, and the county, whatever property taxes they have been avoiding by being in the ag district and getting an ag use exemption, they would have to repay. So it goes into the same pot as a tax.
Okay. Thank you. Jay from Hempstead had a question. It's actually a good one. I had a similar question, so he beat me to it. Hempstead is the biggest town we have in the country, but they have a 50-acre now defunct landfill. A consultant has determined that they could get a 10-megawatt solar field is possible. There is a grid interconnectivity directly across the road. The town legislators are afraid that there may be methane gas leakage if solar panels are installed. Is that a problem when solar panels are mounted? That's a question I've never.
Well, I don't know if we have the technical, I don't know if we have the technical people on this panel to answer that, but obviously there may be ways to site the solar panels on top of the cap, so you're not piercing the cap and getting the methane, or there might be a methane removal system already, and that could be designed as part of the solar. It's very intriguing, and I would, and it sounds like a design issue, not a deal breaker, but it's certainly site specific, very interesting.
All right, our next question is from Michael. Can you comment on the problem caused by state tax in promoting projects that are 5 megawatts max? Some communities are seeing multiple 5 megawatt projects at essentially the same location, which is difficult to get the impacts of multiple projects as the essential segmentation under seeker.
I'll start and then I'll hand it off to the attorneys. It's, the 5 megawatt interconnection limit forces some landowners or, requires some landowners to have more land to develop to do separate projects. I'm going to say my understanding of segmentation, and I'm going to pass it along to Gregory and Allison. If those projects are independent of one another, is that segmentation? If they are 2 different projects, do you need to do 2 different seekers?
Yeah, I think that is the kind of issue that towns deal with when you have projects that are in close proximity. I think in our experience, if I'm advising a town that has a situation like this, I think erring on the side of caution and telling the developer that we want to treat these as one project specifically to avoid the risk of a challenge based on segmentation, because it is one of those things that if someone is looking for grounds to challenge an approval because they really don't like a project, kind of one of the things that's low-hanging fruit for them is there a seeker issue involving segmentation? So kind of erring on the protective side and saying we're going to do the review as if it's one big project in reviewing the environmental impacts is really the safer approach. And often I think you have that conversation with a developer or an applicant, and they say we agree because we don't want our project held up if there is a legal challenge that has a decent chance of success.
Allison, anything you want to add to that?
I think Greg summed it up very well. Yeah.
Okay. Another question here is Western New York has a 500 megawatt application. There are many more projects that are in application phase. Prime soil cannot be avoided. Applicants are either in or plan to be in the Office of Renewable Energy Siting Review. What can a town do to limit development on its sensitive and important land when this process severely limits local zoning code or its energy law?
Yeah, I'll start with that and then let Greg and Allison follow up. It's as an advocate for farmland and agriculture, there's a lot to absorb there with so much farmland going to be developed with solar facilities. And when it's a state process, the state's going to have the final say in the siting. But the town can be very clear as to what its priorities are, which that's why I focused on starting with your planning. What is the town's priorities? And make those clear in your plans and in your local law, which is the only document that the state is required to consider. So it's a consideration in the state siting system. So your priorities should be reflected in your local law. And and as an aside, I do think we're going to see some changes in the amount of farmland, especially in Western New York, where it's all level along the transmission lines. And this might be a change that coincides with a change in the industry.
Yeah, and just jumping off of what Barbara said, the municipalities do have the opportunity to provide comment on projects that are proposed to be located within their boundaries. So detailing the comments and to the extent that the town thinks that the project does not comply with the local law, so outlining that in the comments that are returned to the state. There's the opportunity to at least make it clear what the town's position is.
Okay, we have 2 questions about opting out, so I'll just run through them both. If a town has opted out of the tax exemption in section 487, can they later change their mind and opt back in so that future projects can get the exemption? And then Bob asks along the same line, what if a town does not opt out, but the county and school district opts out?
Yeah, I'll take the first one. They definitely can opt back in. So if a town has opted out and maybe has seen the result being they're not attracting solar and their neighbors are, you can opt back in. The State Department of Taxation and Finance has issued guidance on that, which basically says you opt back in the same way that you opted out. So if you did it by local law or by resolution, you just pass a new local law or resolution that reverses the first one, and you do have to file that second decision to opt back in with the same agencies, Taxation and Finance and NYSERDA, as you did with the original decision to opt out.
Take the second question if you like. So if for example, the school district and the county have opted out, the best way to address this question is think like a developer. So they want to pay as few taxes as possible if they're any kind of good business person. So they'll be looking probably to go to the IDA, in which case the IDA could issue that pilot across the board and assist them with that exemption on all 3 municipalities. But first look at your taxing structure in your area. How much of the real property taxes are going to the town versus the county versus the school district? Because if most of those taxes are going to the town, the developer may prefer to go direct with a direct pilot and pay the other taxes. So I would ask you, get in touch with when you get that letter, the notice for a pilot agreement, reach out to those developers and ask those questions, because you might be able to get a really great pilot agreement with them. They're willing to pay those other taxes. I've assisted a client with doing this in the past, and it worked out great for them. It worked out better for the town. So,
Michael, along those lines, this one is probably for you. Are pilot revenues used to lower property taxes? If taxed at full value, will that lower property taxes?
At no point is it necessarily lowering property taxes, because you're still paying those base taxes on the value prior to the installation of the solar array. A pilot is just additional funding for that community through that agreement, and taxing at full rate increases the tax value. But again, that's really not something a lot of developers want to go into, at least not in the first 15 years of the project. So that's how I think the guidance I would give on that. If anybody else wants to comment, please jump in.
Yeah, I think maybe the commenter was wondering about how much revenue can the town expect with a pilot compared to property taxing, opting in, right?
Gotcha. Well, the issue here is that decision is up to the assessors in that community. And I loved how Greg stated, I'll just throw a number out there. That's essentially what we see on a grand scale across these communities. The assessments are all across the board. Some are based on financials and cash flow models. Others are based on the valuation of the equipment being installed. It's very vast, it varies by every single community we come into. So there isn't really an answer to that question. You'd have to work with your assessor and see how they would assess that difference in property value after installation.
Oh, all right, thanks. I have 2 quick questions. I think that'll do it for us today. The first one is, does 487 specify what form the notice of intent to municipalities must be in? And then is it written or formal?
I believe that the text of the statute says local law for municipalities, like for a town board to make the decision. I think I have seen guidance from either NYSERDA or Taxation and Finance that says local law or resolution. And that might be because in the case of school districts, they obviously don't pass local laws. So I think that a school district does need to do it by resolution, and a town board, whatever they do in the ordinary course of making decisions, I think is okay, but I know doing it by local law would comply with the statute.
Okay, and then finally, we have a question. Most IDA pilots do not require approval of affected taxing jurisdictions. They are at the discretion of the IDA board as long as the appropriate notices are circulated and follow their uniform tax exemption policy. Does this apply to solar projects?
There's kind of a 2-part question, if I could jump on it. One is, it does apply to solar. However, I have yet to work through a pilot agreement where it followed that UTAP. It almost always is a variance from that. And every IDA that I've worked with has been very involved with being in touch with the town and making sure that everything aligns with that town's goals. So the key is just have good communication there. And at the end of the day, the project approval, site plan approval, if there's any variances required, things of that nature, are going to be at that town level anyway.
Any last words from our panelists? I just want to take this opportunity to thank everybody for taking part in this webinar, but most specifically for Barbara, Greg, Allison, and Mike. We really appreciate your time and your knowledge. Again, you'll be receiving a survey at the end of this. Please let us know what topics you'd like us to cover in the future. Please get a chance to go to usesusa.org, and please keep your eyes out for other upcoming webinars. And again, thank you so much to our panelists, and we wish everybody a great day and a great rest of your week. Thank you.